Aaron Markworth, 36 Conkling Road. I'm sure you've had the pleasure of meeting my spouse, Myrna Hernandez, already. I'd just like to read this. This is probably the only time I'm going to stand up in front of you guys, and then, if you'd like to comment afterwards, that would be great. The following reflects my personal opinions and that of some of the other concerned residents in attendance this evening. Today, dump trucks were observed bringing in unknown material to the landfill for unknown purposes under the DEP emergency order. We now know that that was gravel. A major part of the ongoing concerns regarding these and other unknowns are the transparency of the events that have occurred with regards to Fenimore, including conflicts of interest that exist within the council and the town attorney. Today, for the record, I am requesting the following, or for you to make motions to the effect that the town files for an injunction against ongoing DEP remediation until more is known, and does not absolve them of their current responsibility to the site and the problems of the ongoing emissions. That the town also, or possibly the county, files suit to have all the material removed from the site. That is the only long-term solution with proven efficacy to remediate C&D issues, as mentioned previously by Mr. Morocco, who can't be here this evening, and others who have studied the specifics of Fenimore with more detail than myself. The town also should complete and make public that independent report with the Rutgers information, and should also at this time conduct core sampling and stack emission tests at regular intervals allowed under the emergency order. The basis for these requests is as follows. The current DEP proposed remediation is illegal. Mayor Riley, as chairman of the Highlands Council, should be intimately familiar with the letter of the law of the Highlands Act, which makes it so. The DEP granted a Highlands exemption that was incorrectly never challenged by the Highlands Council. Relying on this exemption for protection and decision-making is improper. The DEP has incorrectly stated the closure of the Fenimore Landfill qualifies under Exemption 15 of the Highlands Act because the project is located in a preservation area, and the NJDEP is the regulatory authority to issue the Exemption 15, which is for remediation of contaminated sites. Thus, the landfill closure is not addressed by the Highlands Council Consistency Determination and Final Recommendation Report. This is wrong. But the Fenimore Landfill does not qualify for Exemption 15. By the clear language of the Highlands Act itself, Exemption 15 of the Highlands Act applies only to facilities regulated by the Industrial Site Recovery Act. The Fenimore Landfill is not and never has been an ISRA facility, so the DEP's current landfill closure and remediation plan cannot be conducted pursuant to ISRA and therefore is not exempt under Exemption 15. This should allow Attorney Bucco and or Mayor Riley to petition or sue the Highlands Council themselves to declare that the current DEP plan is inconsistent with the Highlands Act, its regulations, and the Regional Master Plan. Section 81K of the Highlands Act supports this by requiring all DEP remediation, including landfill closure, to be consistent with the Highlands Act regulations and Regional Master Plan, with the exemption of real ISRA sites that are exempted under 15. The law itself states, all remediation standards and remedial actions that involve real property located in the Highlands Preservation Area shall be consistent with the provisions of the Highland Water Protection and Planning Act. Any rules and regulations and the Highland Regional Master Plan adopted pursuant thereto. Section 81E includes landfill closure and other actions pursuant to the Solid Waste Management Act as remediation as defined in Section 81K. Remediation standards and other remediation requirements established pursuant to this section and regulations adopted pursuant thereto shall apply to remediation activities required pursuant to a number of acts: spill compensation, water pollution, ISRA, solid waste management, medical waste, hazardous material, sanitary landfill closure, which Fenimore was a sanitary landfill, and also radioactive waste, which is not applicable in this case, or any other regulation by which the state may compel a person to perform remediation activities on contaminated property. However, nothing in the subsection shall be construed to limit the authority of the department to establish discharge limits for pollutants or to prescribe penalties for violations of those pursuant to the law, or require the complete removal of non-hazardous waste pursuant to law, i.e. truck it out. We were told in the DEP's public presentation that the closure plan is issued pursuant to the Solid Waste Management Act and other remedial laws cited in Section 81. The DEP's consultant presentation specifically noted the regulatory basis for the closure plan. There are federal and state regulations that govern landfill closure. The state landfill closure regulations are adopted by the DEP pursuant to the New Jersey Solid Waste Management Act. This means the DEP itself agrees that the Highlands Act is incontrovertible law. Under Section 81 of the Highlands Act, the DEP landfill closure plan must be reviewed by the Highlands Council itself for consistency with the regional master plan. The Highlands Act Exemption 15 applied by the Council is clearly not valid. In contrast, the clear language of Section 81 was written to give the Highlands Council review powers over remediating landfill sites in the Highlands. The DEP's current plan cannot verifiably demonstrate that it complies with surface and groundwater non-degradation policy of the Highlands Act, as well as the DEP's own surface and groundwater quality standards, as Mr. Medeiros often speaks about. The above facts demonstrate the pathway to an injunction and are solid grounds to pursue such for the good of the community. Again, for the record, I'm formally requesting, on behalf of the concerned residents in attendance, that Attorney Bucco or Mayor Riley, as chairmen of the Highlands Council, petition or sue the Highlands Council itself to assert jurisdiction over the DEP landfill closure pursuant to Section 81 cited above. We request that they conduct a formal consistency review to the regional master plan, which leads to the only proper remediation option of removing all the offending material. As for monitoring of the landfill, the town clearly has rights stated in the emergency order to do its own testing. As Mr. Bucco has previously mentioned, the order itself has two clauses. These state, the Township of Roxbury and its contractors shall have full access to the landfill to monitor all hydrogen sulfide control measures and to obtain test samples for the purpose of environmental monitoring. The second clause is, except as expressly permitted by the department, no person may trespass upon the landfill or disturb or disrupt any of the protective measures or control established or installed pursuant to this emergency order. The second clause is clearly meant for private individuals, as the prior clause directly addresses the rights of our community. The DEP itself is now disturbing the landfill material with the addition of these new gas wells and the addition of other solid material. Now is the time and our opportunity to take core samples of the pile at every location where a new well or piping is being installed, along with stack testing of the scrubbers, as visibly from far away with binoculars, you can see they are corroding and most likely leaking additional hydrogen sulfide and possibly sulfur dioxide. Again, for the record, I am formally requesting the above core and stack testing take place and the results be made public. As usual, we request formal published proof of any request you make to the DEP on the Roxbury website, as well as any responses the DEP provides granting or denying our access. If you, the council, and your legal representative, Mr. Bucco, decline to act on our behalf, I request the council considers appointing a new attorney to represent the town on the Fenimore issue specifically. The Highlands Act was passed to protect us from issues like Fenimore, and there are conflicts of interest and ethical issues present that require new representation. Mr. Bucco himself has stated, and this is a quote, "I believe that the Highlands Act should be repealed due to serious flaws that have adversely affected tens of thousands of taxpayers, families, and seniors. I have personally dealt with the detrimental effects the law has had on the region. After years of broken promises, mismanagement, and miscues, the current law is unworkable and continues to harm the region, wasting taxpayer dollars on incorrect models and assumptions. We are already adversely affected by Fenimore due to the nonfeasance of the DEP and Highlands Council to follow the law of the Highlands Act. The Act represents our legal grounds that we have left to get an injunction and protect the environment in the future. And Mr. Bucco has also spent his private career and time as assemblyman weakening the Highlands Act. He and his firm Johnson & Murphy have a record of condemning and litigating against the Highlands Act on behalf of private individuals and municipalities. They work to protect property values at the cost of protecting the environment. Assemblyman Bucco has sponsored and co-sponsored bills to the same effect, such as A392 and A395, allowing variances, exceptions, and waivers, weakening the Highland Act and emboldening development. His relationship to his father also demonstrates anti-Highlands Act sentiment, as Senator Bucco has tried to repeal and suspend the Highlands Act in its entirety, as in Bill S-355. For these conflicts of interest and reasons stated above, unless action is taken to prove otherwise by the council or possibly now the county, Roxbury needs a new advocate who is willing to advise the council on its full rights and pursue an injunction to protect the residents in the community." Last page. Furthermore, we residents are aware of Roxbury's status as a Faulkner Act Council manager form of municipal government. I'm relatively new to town and I don't know many people. But in light of the ongoing proceedings, I trust all these people behind me a lot more than I trust you right now.
Yes.
Our real estate lawyer had made us aware of Fenimore while our seller did not. And because of this, I called to speak with Manager Rask before purchasing my home in October of 2012. I point blank asked him if there were any environmental issues, variances, or easements regarding my property. We briefly discussed Fenimore, and at the time he assured me truck traffic was my only concern. No mention was made of toxic emissions or the harmful materials that the DEP has already admitted to having been in place as of May 2012, months before I moved in, and that there was going to be more brought in. We residents have also recently been kept in the dark regarding the existence of this DOH health report, which we now know about, the town's own remediation study report, which has been ongoing for some time, and communication with the DEP between the council and the DEP itself, such that it is alluded to by Larry Raganese when he said in the Star Ledger on March 19th, a week after the public meeting with DEP consultants, and I quote, "We have made it clear for months that trucking out the material was not a legitimate option. The governor has stated it, the DEP has stated it, the mayor and council knew that prior to the public session last week. You knew, according to Larry Raganese, before we had our public meeting. Why weren't we told this in previous council meetings? As in all Faulkner Act municipalities, we citizens enjoy the right of initiative and referendum. If you fail to act on our behalf, we will work to craft petition ordinances to protect us that directly affect the surrounding issues of Fenimore and our quality of life. The Faulkner Act is designed for stability and upholding the sanctity of our election process. If residents don't feel the support of the current council, we will put our efforts into making sure Roxbury's next mayor is elected and not appointed by the council, and in running our own candidates to take advantage of our voting rights. The time has passed for partisan politics and defending political friends such as Governor Christie. How is it that we, few individuals here in attendance tonight, have been more effective at bringing attention and response to the Fenimore issue than our own elected officials supposedly serving on our own behalf? Please don't hide behind the curtain of pending SEP litigation. Please don't just kick this problem down the road for people in future generations to deal with. Do something to help us in our time of need. History will judge nonfeasance as being a party to the happenings on the mountain. File for an injunction. Sue to have all the material removed under the Highlands Act, and take an opportunity to conduct core sampling and stack emission tests to determine what is really making us sick. Pending our satisfaction, the next step will be hiring our own representation who will truly advocate on our behalf. Then all parties involved will be under the residents' microscope. Do you have a motion for the 3 suggestions that I made? Will someone make a motion?
I'm not going to make a motion, but can I make a statement?
Sure.
As far as that's concerned. No, look, listen, I can't obviously look at every little thing that you mentioned here, the different...
I'll leave you a copy.
Well, that's great, and please do so. A couple of points that you did make that are absolutely on target that I wrote down here. We absolutely have to get good core samples. You're right on the dime as far as that's concerned. We have to be able to, again, as I mentioned at the meeting that was held, which, you know, I have to apologize to the residents. The NJDEP did an absolutely horrendous job. Well, let's just call it like it is. But the bottom line to this thing, without having those core samples and getting the readings out of those core samples, you're never going to know whether or not you have clean air or clean water. So you're absolutely right on target with that. So we have to force in some way or shape or form the NJDEP to actually do the required testing to provide that information. So, you know, I do hear what you're saying as far as that.
Well, the clock's ticking, John.
Yeah.
Okay.
It's more and more every day. Committing town resources to this, making a motion. I know that there's ongoing and pending litigation, and I know that handcuffs you because you're a part of it. And if you can't do it, we have nice freeholders from the county who are kind enough to join us this evening who have also offered to help. Maybe they have an environmental legal group that can assist you. We're not playing Sim City. It's not a video game anymore. If this is above our council manager's head, then we need to get people. And I don't accept that these Rutgers experts are any better or any more qualified than the EPA experts. So we all understand acute and we all understand chronic. One's very short term, chronic is lifetime. 40 years, this could take 30 years. The community right now is living at elevated levels of anywhere between 12 and 15. So that right now the current DEP remediation plan cannot even guarantee that it will be 1.4 or less, because there's going to continue to be scrubbers, and there's going to continue to be emissions, there's going to continue to be maintenance on that landfill for the next 30 years. Until we know something that's going to have proven efficacy, and until we know that there is a true solution, scrubber aside, wells aside, because picking apart the science is inexact. But until we know, and until more research is done, why invest even $7 million, let alone $38 million, until we know all it takes is an advocate and some good legal advice, which I'm not sure that you're actually receiving. All of this information is available, and in fact, most of the information regarding the Highlands Act came from someone who authored Section 81. He knows what the intent is, he knows what the reason is, and he knows the law. So do the duty, don't be nonfeasant, stand up and take a stand for us. Don't just come to these meetings, don't talk down to us, and don't play like we aren't knowledgeable about this situation.
Yes, sir.
Wait, how about his idea?
There was about 7 or 8 pages of information there.
Well, he asked, sir, to come back up, he asked 3 specific questions. Would you answer them?
Read them again.
The 3 motions is that we as residents want the town to file an injunction against the ongoing DEP remediation. We want to have a suit to have the material removed from the site, as it is only the long-term solution with proven efficacy. We've talked about things like Sulphide Field. I was born in Ohio. There's a landfill there that's somewhat similar to this, different chemistry, but it continues to plague them to this day. And then we want the town to complete and make public all these reports and conduct the core sampling. Realistically, that core sampling, they're cracking that posit shell right now. We should be up there tomorrow. Our experts should be up there tomorrow. The rest of the matters, I realize they take resources, and I realize that the town taking on that kind of effort, both monetarily for filing a suit with the current SCP pending litigation, is difficult. But guess what? It's not easy. Life's not easy. Living every day with the smell, with the headaches, with the nosebleeds, that's not easy. So, I know Mr. Bucco, he hears us, but he doesn't live here in Roxbury. Is he really fighting for Roxbury? I know he's an assemblyman.
These are all options that are on the table to us right now.
So when are we going to know?
Yes or no?
So, in fact, we have an executive session tonight to discuss Fenimore as a whole, as we normally do.
We don't want secrets, we want to talk
Please,
about
Carl,
here.
please don't.
But please answer his questions.
I'm trying to, please.
Make the motion.
It's a yes or no.
It's not a yes or no. At this point in time, it's not a yes or no, because it's an option that's available to us right now.
When will
It's
it
been
be?
an option for
So
years.
have the discussion publicly
Please.
and make the commitment.
Please.
Please tell us, the 2-year option you passed up.
Because soon the DEP will be up there, and they will railroad you, and they will make more of a puppet out of everyone than already. Because that's really where it is right now, is that the DEP is pulling the strings. And that, and not fighting for us,
We are
Is-
fighting for you.
No way.
No, they're-
No.
you're not.
Not
if you were fighting for us,
Then make the
if
motion.
you were truly fighting for us, you would go to the Highlands Council tomorrow. You are the chairman. The Highlands Council, under the Highlands Act, has the rights to take jurisdiction. You are their chairman. I know Mr. Fail is retiring. Good for him. I know there's a lot of politics involved there as well. I'm not, party to obviously everything that's going on, but this is a simple matter that there's a letter of the law to be followed.
By the way, the Highlands Council is a bipartisan,
It was.
Okay.
It was until it
No,
was
it was-
disassembled by
it was
Governor Chris.
There was one party in Congress, and now it's two parties.
That's enough. We're not going to come to any answers tonight,
But
but you know where we stand.
The Highlands,
And you're on the clock. You are on the clock.
Thank you.